right, why don't we get started? There's a lot to cover, and we only have a short amount of time. I'm Al Hochheiser from Maurice Witcher, and I've been practicing bankruptcy law, collections, and also doing compliance work for the auto industry for over 30 plus years. And today we're going to talk about in the presentation, which is going to try to be very interactive, so any questions you have, I'm going to throw out questions to you. Please feel free to jump in. But are you seeing an increase in bankruptcy filings? How to prosper, how to avoid sanctions, which we're seeing a lot of, and how to do it right when you have a customer that goes bankrupt. Have to put in my legal disclaimer there. This is not legal advice. If you have questions or your own situations, seek out your own attorneys. This is just to give you some overall information as we move forward. So the place that I want to start, and it's great because I love talking about bankruptcy in Las Vegas, because if you look down the strip, you have Caesars. Caesars has been bankrupt now for over 4 years. So here you have a casino that's still operating. And then, you go to the casino floor, and there are a lot of bankruptcy connotations. So, you're playing craps, and you have 7 and 11, chapter 7 and 11, and sometimes it's good, sometimes it's bad. You have all those numbers coming up in roulette, so I always enjoy being in Vegas to speak about bankruptcies. But what are we seeing in bankruptcy trends right now? So total bankruptcy filings through April 30th of 2019 were 258,387. Okay. Last year in 2018, we had 755,000 bankruptcy filings. And in 2017, it was a little higher, 766,000 filings nationally. So the first question to the audience, does anybody know what the largest amount ever of total bankruptcy filings were? It is in the millions. I'll give you that hint. Do we have any guesses? I'm sorry? Well, it was 2005. I'll give you the year. Does anybody know how many bankruptcies were filed that year? Very close. You're a little high. But 2.1 million bankruptcies were filed. Okay? Now, the reason why we saw so many bankruptcies back then was that was the year that they basically rewrote the bankruptcy code. So everybody was running out to file before October 17th, which was the date that the law went into effect, because everybody was advertising saying, file bankruptcy now, because you would never be able to file again. Well, that wasn't the case. Bankruptcy slowed down, and the good thing is, when you look at the numbers over the past 2 years, we're seeing, stability in the number of bankruptcy filings. Here's a breakout of the bankruptcy filings by chapter. So Chapter 7 is a liquidation, and what consumers attempt to do in a Chapter 7 is to discharge all their debts except certain debts that they want to keep. And hopefully with your auto loans, they want to keep those loans and they'll reaffirm those, and we'll talk about that a little bit later on. Chapter 11s are primarily business bankruptcies. We are seeing an uptick in business bankruptcy filings this year. Just in May, from a year before, business bankruptcies were up 7%. And we'll talk a little bit about how that affects your businesses. And then there's Chapter 13s, which are a wage earner reorganization. And what the consumer is trying to do is put together a plan to pay back his or her debts over typically a 5-year period. And that would include secured debt on your car loans, as well as unsecured debts of credit cards, student loans, telephone bills, utilities, etc. But as we can see, that it's pretty much consistent of how that breaks out, with 60% being Chapter 7s, a small 1 or 2% Chapter 11s, and the rest Chapter 13s. Okay. So here are the last 3 years of the number of bankruptcy, the states with the highest per capita bankruptcy filings. So in Alabama, in 2019, 5.27 households out of 1,000 filed a bankruptcy. It's a pretty large number. And if you can see, it's pretty consistent on the states over the last 3 years and even going back, where the states in the South tend to see higher bankruptcy filing rates per capita. Now, part of it is some of those states are smaller, like Alabama and Mississippi, but you also have Tennessee and Georgia, which are pretty populous states. One of the reasons, and if you have dealerships, your dealerships in that state, you have to be a little bit more concerned and you have to look at your credit processes a little bit differently, is because of the exemptions. Those states have very small exemptions, so individuals are filing bankruptcy so they don't lose their houses and they lose their cars. So I'm going to throw out another question to the audience, and I got to check my little cheat sheet here. Which state do you think has the lowest per capita bankruptcy filings in the country? We have a Texas, Minnesota, and I know you're from Minnesota, right? Because you raised that in the session this morning, so I was paying attention. Alaska. Alaska is 51 because they just don't have the population, and that they're at a 0.56. But some interesting numbers to throw out to you. Nevada, where we are right now, 4.03 out of 1,000 households file a bankruptcy. They're number 7. Florida is number 16, and they're at 3.47 households per 1,000. California is number 26, so they're pretty much right there in the middle, probably one of our most populous states at 2.75. And New York is number 40 at 1.62 households per 1,000. So it really makes a difference where you are in the country to see how many bankruptcy filings that are out there. Okay, so let's talk about what happens when a bankruptcy is filed. Is everybody familiar with the automatic stay? Okay. Automatic stay, not your best friend, okay? So when a bankruptcy is filed, as soon as you receive notice of that bankruptcy, and there are a lot of different ways that you can receive notice, okay? It may take a couple of days and you'll get an official bankruptcy notice from the court. You may have the consumer let you know because, guess what, they missed a payment. And you're on the phone saying, where's your payment? And they say, well, I filed bankruptcy. Or you may have an attorney send you a letter right away, email it, fax it, whatever it is. But as soon as you are aware that that bankruptcy was filed, all activity against the debtor must stop. You can't make any collection calls. If your car is out for repo, you can't do that. Not necessarily, because there's some different case law in that. We're going to get into that. And that's one of the important things, because it differs around the country. And but you're right, the majority opinions is you have to give it back if it's repoed. The other question is there insurance on the car, which plays into effect as well. But anything that is going on to allow you to either get paid, take possession of your car, or you may have it out with an attorney to sue because you have a deficiency balance now after the sale, all of that must stop. If you are taking any actions, you are opening yourselves up to potential violations of the automatic stay. And the courts out there on these days are not very friendly. We have a debtor's attorney bar in bankruptcies now who, because of the smaller amount of filings, they're looking for any way to be able to make money. And they know as soon as they raise an issue as to a violation of the automatic stay that they may be awarded attorney's fees. Now, what do you do in the situation is, example there, Michael, you went out and you repossessed your car, but you didn't have notice. Did you violate the automatic stay? How many people think Michael violated the automatic stay? I got one. Oh, even the camera guy has his hand up. I like that. So we have 2 or 3. Okay? We got another one. Okay? Well, you're right. Michael did violate the automatic stay. However, it was not willful. He didn't have any notice. So although the step that you took, you need to put the debtor back where it was prior, at the moment it filed bankruptcy, he or she filed bankruptcy, but is a court going to sanction you for that behavior? And the answer is going to be no. And that's the main difference. So what do you do in the situation? You say, okay, we just repoed the car. Yep. Do you have insurance? They have insurance. We'll use the easy example. You give them back the car. And this doesn't matter if it's a Chapter 7 or a Chapter 13 proceeding. It's in any bankruptcy or the few Chapter 11s, but it's very unlikely any of you will be involved in the 11s because individuals typically don't file them unless they have an extreme amount of debts and assets and they don't qualify for a Chapter 7 or a Chapter 13. A Chapter 13. You'll always qualify for a Chapter 7. So, how do you find out about it? So, you get an irate attorney on the other side that says, you better give me the car back because I'm going to go file a motion for sanctions. We're going to drag you into court. That's a good attorney because he's calling you up and he's saying, or he sends you a letter or an email, give it back. Unfortunately, too many times what you see is attorneys who will just go ahead and file their motion for sanctions. And that, changes the situation a little bit. And that's where you have to decide how hard you want to fight it back. Okay? What it's going to cost you to defend that. Because I'd be very confident in the situation that we just gave where there was no notice of going into court and saying, Judge, if this attorney would have picked up the phone, sent an email, we would have given the car back and put the debtor exactly where he or should be at the time of that filing of the bankruptcy. Instead, he files his half-cocked 18-page motion for sanctions saying the dealership is horrible, we repossessed the car, we should have known about the bankruptcy, even though we didn't get notice. He's asking for $5,000 in attorney's fee because, of course, he's charging his client $450 an hour, theoretically. There's no debtor's attorney who charges a consumer $450 for that. And I'll tell you a true story. I had a case out in California. Anybody here from California? Okay, a couple. And my client violated the discharge injunction. So we'll talk about that in a couple of minutes. But so they had to pay out some money. So we settled the case for absolutely a reasonable amount. So the attorney sends me his fee bill, and it's at $535 an hour. This is a consumer who just filed a Chapter 7, okay, and violated the stay. So we settled it, and I said, well, your attorney's fee rate is a little high. I said, do you want me to put in the order that we're going to pay the debtors X amount for their damages and your attorney's fees at a lower amount? And flat out he said no. I disclosed to the court that I would charge them $535 an hour. But these are how those attorneys are out there, and they're looking to go after the entities for the slightest violations. So sometimes you have to really belly up to the bar and say, yeah, we have to defend these. Because you know what happens? Especially in some of these jurisdictions where you have debtor mills of attorneys. They're the ones filing the majority of the bankruptcy cases. They're going to come after you every time for the slightest violation, and sometimes you have to put it to rest. So on those situations, best thing is go talk to your counsel, make some determinations, and look, if you did nothing wrong, because you didn't have notice. You can't be threatened all the time. It has to become an economic decision for you to make in each of those situations. Okay.
How accurate does the information have to be on the lender? If you say they list you, but they don't list your business or your correct address.
Great question, okay? It has to be where you had actual notice of the filing. So if they're sending it to a wrong address, they list the wrong name of the entity, and we see this a lot. My firm represents a lot of debt buyers, okay? So they're putting the original creditor in the bankruptcy petition, and they're serving the original creditor. Well, my client has been suing you, going after you on collections. You have all this information, but the problem is they're not reporting to the Bureau. And a lot of attorneys get lazy, okay? So what they do is, all they do is run a credit bureau, okay? And they don't see the secondary entities out there, especially if they don't report. So they never listed in the bankruptcy. If you don't have actual knowledge, you're not going to be, you'll be governed by the automatic stay, but it's not going to be a sanctionable activity. Let's go back and then we'll move up. So, the young lady. Okay. Yeah, and that's a great example for the question, if you all couldn't hear it, is there are some entities that go out there and use the national bankruptcy system, PACER. Has everybody in here used PACER to check the status of bankruptcy filings? Okay, it's a great tool because besides learning, as in this situation, if there's a repossession, when you're going out to repo to confirm if they're bankrupt, it also gives you a lot of other information in the case. You have all the attorney information, so it makes it real easy. So that's a great thing, and you save it. So the downside of that is if you're not listed, you now have actual knowledge, but you're protecting yourself and you're not running the risk of being sued. Okay. Yes? Okay, so first off, when a debtor files a bankruptcy, any and all liabilities, any and all assets of the debtor must be listed. When the debtor says, oh, I'm not going to put it in there, and you see it a lot with buy here, pay here, because they don't want to risk losing the car. Okay, they need that car for transportation, they need to go to work. You see it a lot with credit unions. Same thing, you have the credit union that they always see as the entity that's going to lend them money, so they tend to not list it and keep making payments. But technically that's illegal, okay? And because of that, you don't have notice and you don't know anything that's going on. You're getting paid, which is great. The proper way to do it is to list it in the bankruptcy, make a determination that they're going to reaffirm on the debt and keep the payments going, so that debt will survive the discharge after the bankruptcy is filed. So if you know about the bankruptcy, but they didn't include you, that's your actual knowledge and you will be subject to the automatic stay. So if you end up going to repossessing your car because there's a default, a court's going to find that it was willful because you knew about the bankruptcy even though you weren't listed. Sir, you had a question? Right.
Now, my girls have been trained to put a notice in, or they hadn't. Cannot contact somebody. But we also found that in a high percentage of those, they haven't filed it.
Right.
They haven't paid the attorney. Consequently, the attorney isn't going to do any action without the money. So we check PACER and NIADA and make sure that they in fact have not, and then go ahead with a repo.
And that's actually you should do. So the question was on collection calls. Sometimes the debtor says, I filed bankruptcy. Well, they didn't really file bankruptcy. They went to their attorney. They started to fill out the paperwork. They haven't paid the attorney a $750 fee or her fee, and as a result, it wasn't filed. Or it's also a situation that they may need additional documents as to property ownership and things of that nature. The best thing to do in that situation, you have a great backup plan because you keep checking Pacer, but the other thing is ask for the attorney's phone number. Okay? Pick up the phone, call the attorney, and they'll typically tell you, we didn't file yet. Okay? We're waiting for documentation, we're waiting to pay, and guess what? We think it's going to be in about 2 weeks. So that, manages your expectations so you're not sitting there continually making collection calls when you know they're going to file. But then you have the other attorneys out there who say, look, I'm waiting for all this documentation. Don't stop what you're doing. Don't stop your repossessions, especially because we all know and we all have the stories is, someone says they filed bankruptcy, or someone says, oh, we're going to come in next week and we're going to pay you because we're getting a tax return, we're, whatever. And guess what? That car ends up in the accident and there's no insurance. I mean, we see it way too many times. I mean, we all have those war stories. So our advice is never stop until you have that confirmation of what you're doing. But, if it's a one-payment default, something like that, then what your business policy and what your business decision is. Sir, you had a question.
We see a lot of 13s that come through where the people list no asset other than their car, and their income is below the median for the city,
Right.
The city in which it's being applied. What can you do to get that thing back to where it should be, and that's in the second?
Well, so you brought up two issues. So the first issue is in Chapter 13s where you're seeing the debtors are filing the case basically to be in a position to keep their car. They're below the median income line. Now, what the median income line is, and this goes back to 2005 when you had all those filings, they put in this, whether the debtor is in Chapter 13s, if they're above the median income, they cannot file a plan less than 36 months. It has to go full term to 60 months. If they're below the median income, they can file a 3-month plan and pay less back to their creditors. But what's going to happen in Chapter 13s with cars? And I'm going to jump ahead a little bit. Right there. Oops. Talking about valuation of collateral in Chapter 13s. Your cars should always be paid through the Chapter 13 plan. But what's going to happen is it's going to get paid based upon what the car is worth. So the debtor can say, look, we went out, we bought this car 4 years ago, okay? We paid $10,000, but today, looking at Blue Book, NADA, Black Book, whichever source you use, it's only worth $4,000. So now what we're going to do is pay you that $4,000 over a 60-month period, okay? And now you're getting, whatever it is, $100 a month, well, less, so $80 a month. My math is not good on my feet. So, and the other thing they can do is they can cram you down on your interest rate. So you may have an obligation out there that's at 14.5%, but the current interest rate in your area, the national interest rate, is only 6%, okay, or 5.5, depending on what the Fed does. So there was a Supreme Court decision many years ago called RASH, TIL. RASH was the valuation, okay, TIL was the interest rate. And the Supreme Court says that a debtor should only pay back what the average interest rate is in your area based upon what the prime rate is, plus a risk factor. Now, on most of your obligations, unfortunately, your debtors are a little more risky. So maybe you can get the debtor to go into like 9%, but you're not going to get your 14.5% unless the court approves it. And you're going to have a little bit of a tough argument there. The second piece of that on valuation is there's the Rash decision, which basically says the value you use is the retail value of the car, which is very good for creditors, okay? Because most debtors' attorneys, when they value cars, they're either using the lowest value, the trade-in value, on a car that's in poor condition, okay? And so they're looking at every way to pay you less. But one of the things that you need to be aware of is a thing called the 9-10 rule loan. Is everybody familiar with that? And basically what the 9-10 rule says, that if the debtor purchased the car, okay, within 910 days of filing the bankruptcy, they must pay you 100% of the value. Now, it doesn't matter that it's a 2010 car. It's just if it was purchased within those 910 days, you're getting full value of the car and they cannot cram you down. They can cram you down still on the interest rate, but at least you know you're getting the full value. So in my example on the $10,000 loan, now instead of getting $85 a month payments, you're back to getting, with interest, $200 a month payments through the plan. So when you're reviewing Chapter 13 plans, when you're listed, it's very important to take a look at the valuation, and you may need to go in there and file an objection to confirmation. What do you do, and I'll throw this out, are you filing objections to confirmation of plans when you disagree with the value? I got a no over there. Okay.
We have an attorney that she keeps up with all my things, so something's coming up. You're talking about waiting 4 years or 900 days. My people buy a car in 2 weeks, they make their first payment, the next 2 weeks I have a bankruptcy.
Unfortunately, we're seeing a lot of that.
And they're not paying the attorney. The attorneys are putting them on a payment plan, and we don't get money for 6 to 8 months.
Right.
We say, if that, and then if we say anything, their attorney is like, what are you saying? You're not getting that, well, you wrote the check, I didn't get it. You know, so we just hired an attorney, and she goes in every morning and checks bankruptcies to make sure nothing does come up new, that she goes to court. I mean, if you take my car for 2 weeks or one payment, I want my car back. So we go in and try to get a relief from state to get our car back.
Right. So,
It gets expensive.
and that's the downside of it, because if you look at it, okay, and you brought up several good points here in the Chapter 13 process. The Chapter 13 process is slow. So what happens is the debtors file the case, and then 30 to 45 days in, they're going to have a first meeting of creditors. Now, the Bankruptcy Code says that Chapter 13 shall come up for confirmation within 60 days of filing. Find me a court that confirms a plan within 60 days, and then let's all go down to the casino right now and we'll be rich, because they're so few and far between. So what happens is the debtors are always asking for the extension. So their plan's not confirmable, or you have a creditor filing an objection to confirmation. And sometimes these drag on for months. 6 to 8 months is not uncommon. I had a client, major auto financier in the country, and this is years ago, and we had a relatively new judge in Cleveland, the Northern District of Ohio, and they just couldn't understand why the plans weren't getting confirmed and why they weren't getting paid. Now, we'll talk about adequate protection, which is new, in a minute, but so I said, come to court with me. You know, we had an objection to confirmation on there. They came to court. 5 out of the first 6 cases, the debtor's attorney gets up there and goes, Judge, we need more time to make our plan work. We asked for an extension. She extends it out 6 weeks. 5 out of 6 cases said, Al, we're done. Let's go. And we went to lunch, and they understood. So the court process doesn't help it. But what can you do? Okay, so one of the things, when a debtor lists you in the plan, they're supposed to make adequate protection payments. Okay? which, if not your monthly payment that they're proposing in the plan, at least a percentage of it, so you're getting some money in while the plan is gearing up to be confirmed. Okay? It could be. So a lot of them put in 10%. Others will pay you the amount of your regular monthly payment, but that's few and far between on that as well. But part of the problem is, who makes that payment? Is it the trustee or is it the debtor? Technically, it's supposed to be the debtor and not the trustee, Chapter 13 trustee, to make the payment, but Chapter 13 trustees want their money. So Chapter 13 trustees take a percentage of all the dollars that go into the plan. And it ranges anywhere from 6 to 10%. And I can tell you today, most of them are in the 8 to 10% range that are out there. But pushing for that adequate protection, and that's when you talked about filing a motion for relief from stay, to go to the court and say, look, this plan is just extending out. The debtor, if they're not funding the plan to the trustee, that's grounds for relief. Okay, but we need our adequate protection payment. And the problem is that they can come back and say, you're going to get 10%. So we're going to pay you $200 a month. You're going to get $20.
I've had it, my software only amortized the loan for 10 years. I've had the AP so low that I couldn't rewrite it with the cram down and stay within the 10. My software wouldn't even amortize the damn.
Yeah. And that's part of the problem. And I always said I could retire real quickly if I have the knowledge of what it should look like, but if I ever found someone to do a program that could, fix that problem, because you see the same thing on mortgages, getting dragged out with arrearages and all that. The debtors play the game and they use the bankruptcies to their advantage. So the key piece of it is, you need to be aggressive, but it does get expensive. So besides the fee that you're paying your attorney, okay, you're also paying a court cost to file a motion for relief from stay, which it just went up recently in April because every couple of years they change it to inflation, but it was like $181 a pop. So it may be in the 190s now, on top of whatever you're paying your attorney. So let me throw the other piece out there on Chapter 13. Well, that's it. You had a really good judge.
Well, I'll tell you what it is. We go, the attorney gets, as soon as the insurance cancels it.
Well, that's a different story. That's a different story. So, and well, but the, right. So, right. So, I mean, those are other pieces. So, if they're not funding the plan, that's another way to get relief from stay. The lack of insurance. But the other thing to be aware of, and I'm going to jump off of 13s for a second because you raised a really good point. They made one payment and then they filed bankruptcy. Well, one of the things in the Chapter 7, and I talked about it right in the beginning, is that the debtor's goal is to obtain a discharge. So get rid of all the debts besides the debts that they want to keep. Now, if you have a good customer, and you see a lot of them, that they do come in a week or two before filing bankruptcy, and they want to get a car that's reliable, they know they're going to need it to go to work, they file a Chapter 7, and one of the things that they do, and I'm going to jump ahead here, they're going to reaffirm on the debt. So they say, look, we know we just got this loan, but we're going to pay you, okay? We want to reaffirm, so they fill out an agreement that gets filed with the court that basically says we're going to continue to pay you, and that when we obtain our discharge, this debt is going to survive. So 4 months after discharge, and they're paying you, and all of a sudden they default, you can go out and you can repossess your car. you can go and sue them for the deficiency. You can do all of those aspects. Does everybody utilize reaffirmation agreements? Yes, ma'am.
Is anyone else seeing an increase in the attorneys telling their clients, just keep paying, we're not going to reaffirm?
Okay, so
I'm seeing an awful lot of that, which is fine if the car keeps running.
correct. So what you have there, even though retain and pay is not an option. So when a debtor files a bankruptcy, they must provide their statement of intentions. And in the bankruptcy schedules, there's actually, after schedules I and J, is their statement of intentions. But most of the time, they're blank. Okay? But the debtor is required within 30 days of filing the case to state his or her intentions as to secured property. So they should put in there, you have two options. It's reaffirm or surrender. There's no retain and pay provision. Now, what most of the attorneys do is say, they type in, we're going to retain and pay, okay? And you're right, it's good because you're getting paid, but what happens when they default? Okay? Your debt is discharged because they didn't comply with it. And the other thing is, besides stating, they must comply with their statement of intentions within 45 days of the first meeting of creditors. So if they say they're going to surrender, they should surrender, or they should execute a reaffirmation agreement, which gets filed with the court. The other thing you might be seeing is there are times that a debtor wants to reaffirm, but the attorney doesn't believe it's in his or her client's best interest. So what do? They won't sign off on the reaffirmation agreement, so then there's an automatic hearing with the court because the attorney didn't approve it. So, we're seeing a lot more of the retain and pay situation because they don't want to lock in the debtor in case there's a default. But, well, right. But they never execute it, right. Right. Well, you can file a motion for relief, but then you're back to the cost you money.
Let's roll the dice downstairs and...
Yep.
I think they're doing that as exercise this week. And that it used to be forever. Retain it or reaffirm or repossess. I mean, those were the three options you had.
Right.
And about 4 years ago, I went to a meeting of creditors, and I had a conversation with the attorney there and the trustee, and the trustee said, no, they're payments are fine. They can see if their vehicle. Like, nowhere is it ever written that that is an option. But again, it's more money to file it and let them pay it.
Yeah. I don't like to tell political stories, but it only became political because this individual is running for president. So this goes back 15, 20 years, and I was at a conference, and this individual was on the panel, and she was talking about how reaffirmation agreements, she would never have her client sign them. And I raised my hand and I asked a question. I said, what do you do the day after discharge and your client misses a payment? I said, my client's going to go repossess the car because there's no longer a grace period that's out there. And at that point in time, the individual goes, yeah, you're right. It is the risk at that point in time. So that's the way when you talk in debtor's counsel is, look, your client is losing all the grace periods. They're losing all their other rights that they have under the terms of the underlying promissory note or installment loan agreement. Get them to reaffirm. So that's one of the sales pitches that you could use out there.
You mentioned insurance earlier. We lease, so we don't have a lot of problems with that. But insurance in a lease situation, it's not covered by the bankruptcy court. What are the provisions in that?
So you mentioned leases, which is real interesting because there's a whole different portion of the bankruptcy code that covers leases under 365. And basically what the bankruptcy code says in Chapter 7 is that any executory contract which is not assumed within 60 days of the filing of the bankruptcy is deemed rejected. So at that point in time, what you have is a situation, and the amendments to the bankruptcy code said, if they don't sign a lease assumption, and some courts also say you should have a reaffirmation agreement along with your lease assumption, you can go pick up your car after 60 days without a further order of the court.
Now, we talked immediately, but my real question is the insurance part of that. If they are uninsured,
Right.
driving that lease vehicle,
File your motion for relief on day one.
so you can file a motion for relief and make them either approve insurance or turn the car over.
Exactly.
Okay.
Yep. And anybody can do that at any point in time. You know, you hear a lot of times you can't file a motion for relief from stay until after the first meeting, and that's not correct. If there's a lack of insurance, you are not adequately protected, and you're entitled to your car, at least get in the court, to say, turn back the car, or you can go and repossess the car out there. Boy, we're really coming up on time. Let me see what else. So let me just open it up to any questions, because you've been a great audience and have a lot of questions. Yes?
Mine is related to bankruptcy and credit reporting. So when they do write this, which is happening to us all the time as well, my understanding is this is discharge and stop reporting to the credit bureau, but then the customers are complaining, like, why am I paying? Because they're not helping my credit.
All right. So I came from an interesting session that TransUnion did across the hall, and they were talking about alternative data. Okay? And one of the questions, which I didn't get the chance to ask, was discharge happens. You know, you stop reporting. You're reporting the debt as discharged unless there's a reaffirmed debt. Okay? Or during the Chapter 13, you're reporting included in the Chapter 13. But debtors are out there saying, we want this good credit because people like TransUnion are picking up that data, and that's helpful to other, future credit grantors. And you're under no requirement to report it. And as a matter of fact, I think you may be in violation of the discharge injunction if you do, in fact, report it. And the next thing someone's going to come back and say, class action. Okay, you're reporting on a debt that has been discharged. And I've defended a lot of actions for FCRA violations by our clients for either reporting or not reporting correctly. But that's another tool you could use to get the reaffirmation agreement. And there was an attorney down in Florida I used to deal with a lot, and he said, we're going to reaffirm, but we're only going to reaffirm if your client's going to report the payments on the credit bureau, because that's going to be the way that my client rebuilds his or her credit in that case. But that is a really difficult situation. Sir.
This may be a one-on-one type question, but it's Chapter 7 or 13, when a new purchaser comes to me and says, hey, I filed Chapter 7 or 13 a month ago, or I'm in the middle of a bankruptcy situation. When is it okay for me to sell them a car?
Okay, so that's a great point. So Chapter 7s, anything that happens the minute after they file, it's not subject to the bankruptcy case. So you could sell them that car right there if you choose. Even before the meeting of the creditors. What the bankruptcy code says, at the moment of filing, all assets of the debtor become assets of the bankruptcy estate. All liabilities are locked in at that point in time in a Chapter 7. What happens after that is free game. And guess what? Take your situation where, your customer made one payment, so they make one payment after your new loan after Chapter 7. You're suing them. You're repossessing your car. You have no limitations. Chapter 13 is a little different, okay, because that's an ongoing process. The debtor technically can't enter into a new obligation without court approval. There are courts that say, yeah, you can incur $1,000 like ordinary course debt, but if you're entering into a new loan, you have to have court approval to enter into that new car loan or a new mortgage on your house. So, and there have been times that courts have stuck the creditor and said, look, you contributed to this, and the debtor is now paying you X amount of dollars a month, and that money could have been used to fund a Chapter 13 plan.
So you're saying, I may have misunderstood. You have to have the approval of the bank.
On a 13. No, court and the trustee. Yeah, on both. But typically what will happen is the debtor's attorney will file a motion to incur credit. So their car's breaking down, or motion to substitute collateral. All that needs court approval. Chapter 7?
Is there a situation where I feel like I've heard these people say, well, I filed a 7, but we might roll it into a 13 or some nonsense like that.
Okay, so
I could get something back in.
No. Yeah, so they file, it's called Chapter 20, okay? So 20, it's okay if you're at the blackjack table as long as the dealer doesn't have 21. In bankruptcy, you don't like Chapter 20s as a creditor. So what the debtor is doing is they go and file a Chapter 7. They discharge all the underlying liability on the debt. The lien survives. So if they didn't reaffirm, so let's go back to your situations there. So they file a Chapter 7, they didn't reaffirm. What happens? The only thing you can do is look to your car after discharge. Okay? You can't sue them for any deficiency. So what they're doing now is they're saying, we still want to keep our car after filing a Chapter 7, so we file a Chapter 13. That's where you get your 20. Okay? And now they're going to pay you 100%, but they're going to spread it over 5 years on a repayment plan for you. And you know what? They're going to take the till interest rate. And on top of it, if it's not in 910 days, they can cram you down on value. So you have all these pieces in a Chapter 20 situation that are not really good for auto lenders. So it's something definitely to be aware of. And at times we'll go in and object to the confirmation of the plan, or we'll file a motion to dismiss and say, this is just all, fraud. We should be entitled to our car.
We see the opposite. I've never seen a 7 and then roll it often. And we always blame the attorney for it, quite frankly. So they get, but we'll see it very regularly where they'll file a 13, jackass around for.
Right, and then it converts to a Chapter 7. Right, they don't roll it. The court converts it to a Chapter 7, or they do it voluntarily, and then they go through that process. The other things, if you look at it, okay, if a plan gets confirmed, okay, and I actually pulled these statistics because I thought they were really interesting, and that on confirmation of a confirmed plan, depending where you are in the country, 52 to 69% of those cases will complete. So the debtor will complete it, pay everybody back what they're supposed to, and it will take 5 years, but you're getting your money, what they proposed in the plan. However, cases that, if you look at overall the number of cases that completed that don't get dismissed, it's only about 39%. So 61% of bankruptcy Chapter 13s in general don't make it. So those are some staggering numbers, and that's where you see conversions, or you see the debtors making multiple filings. It's not uncommon to see 3, 4 Chapter 13 filings.
Then they keep your car for a year, drive it 80,000
Right.
miles, and then roll it to a 7 and give it back to you.
All right. So I know we're out of time. I'll stick around for more questions, but if anybody needs to leave, feel free. And I thank you for your time.